Hello everyone, my name is Damien Gerardin. I'm a professor and a lawyer based in Brussels, but also teaching in Washington. And today I've been asked to interview my friend Jacques Steenbergen. Jacques is a very prominent antitrust expert. He had a long career in the field and is currently the chairman of the Belgian Competition Authority. So Jacques, maybe to start, could you briefly describe the milestones of your career?
I started as a research assistant and wrote a doctor's thesis on legal remedies in ailing industries. And the more I wrote about it, the more ailing industries there were, because that was the crisis of the 70s. So I prefer to move into more future-oriented activities, because with ailing industries there's only so much you can do. And through industrial policy, I came to competition. I practiced both corporate and competition law for some time. I was legal secretary to the President of the Court of Justice, and that was really a turning point as from then focused primarily on AU and competition law, even though I continued to do corporate, but then only corporate cases where there was a competition side to it. In about '84, I joined the bar and stayed at the bar till 2007 in a firm basically always in the same office, but which partly through my involvement and otherwise merged a couple of times. First we came from a Belgian firm, a Dutch-Belgian firm, and then finally we merged with Allen & Overy. And when I was approaching the retirement age for partners, I told the partnership that if I saw something really interesting a couple of years before, I would move, and that's what I did. And I became the Director General in the then Competition Authority, was involved in the reform of the authority, and the government appointed me the President of the present authority in 2013. Mm-hmm.
Great. So you did a lot of different things. You started in academia. You continued in academia because until recently,
till last year.
Yeah, exactly. You taught at Leuven University, which is a large Belgian university, a very prominent university in Belgium. And then, of course, you practiced law. Then you became an antitrust official. Do you think there's synergies between these different roles?
Obviously. First, enforcers do not have some secret toolkit practitioners do not have. We really practice on the same planet. Mm-hmm. So the move from the one to the other is more natural than people may think. Second, as a practitioner, I was not really a litigator. I really think that in the practice of law, you have two key models. You have litigation, and you have, whether it's consultancy or judging, enforcing, doesn't make too much of a difference, even though you have also consultancy with regard to litigation. But a litigator, he looks at the facts and at the law in order to defend the position of his client given the facts. Mm-hmm. As a decision maker, but also as a consultant, you look at the facts and the law and you try to see what the solution should be without being guided exclusively by the interest of a given party. So a consultant basically, and that is what I mostly did in practice, tries to figure out what the enforcer is going to decide. Mm-hmm. And I'm still trying to find out what the enforcers should decide.
Exactly.
So there is a greater degree of continuity than many people may think.
Right. And so you've been practicing EU law and EU competition law for many years, maybe 30 to 35 years. So what are the main changes you've seen during these 3 decades in terms of practicing competition law?
From the specific perception of a practitioner in Belgium, one of the key changes is that national competition law has become more important over the years. And obviously, as the head of the Belgian competition authority, I'm inclined to see it from that side, if not only from that side, because of our involvement in the ECN. So that is, from my perspective, certainly, but I think also from the perspective of many practitioners, a major change. Within the field of competition law in general, there have been changes, absolutely. You have the greater weight that is given to economic analysis and economic arguments, especially in abuse for US audience unilateral conduct cases and merger control cases, but also in the less obvious, less hardcore cartel cases. You have more over such a long period of time, you see that there are many more unilateral conduct abuse cases than there used to be in the beginning. In the beginning, you had them at the national level, but not that many at the AU level.
Right.
That has changed. And merger control has had its ups and downs together with the M&A market.
Of course. So what do you think of this increasing role of economic analysis? Because recently, after the Intel decision,
Yes.
there's been a fairly public debate about the role of economic analysis. If you read the decisions of the Commission, they're becoming very long, very detailed, sometimes confusing. So do you think there's too much economic analysis, or you think that it's not in terms of too much or too little? What do you think about this evolution with more economic analysis in the process?
Well, first, competition policy is about market government. So obviously, economic analysis and economic assessment has to play a significant role. You want to impact on economic activity. You cannot expect to do that if you do not do it from sound economic premises. That's one thing. Second, and that's for me a really different question. The second question is, should you have an in-depth economic analysis in each and every case? From the point of view of a small authority, but I think even of the large authorities, it is simply not feasible to have an in-depth economic analysis in each and every case. So what we definitely need from the perspective of an authority like the Belgian authority, but also I think from the larger authorities, is a sound economic assessment of issues and behaviors, and which allows us to decide which types of behaviors can be assumed to be harmful and which require a case-by-case analysis. So I'm not too happy with the idea that you have, to use the European terminology, to have the infringements by object and the infringements by effect. And what you can now sometimes read in the very interesting comments on the Intel case is that those who prefer the infringement by object are against the economic analysis. That's not the way I see it.
Right.
For me, the difference is rather that in a number of cases, the economic analysis should come up front. And once in a sound, solid economic assessment, you reach the conclusion that a certain type of behavior is bound to be harmful, then you do not, I think, require to go back into the analysis every time you have a similar case.
Right.
On the other hand, if you cannot reach the conclusion that a certain type of behavior can be assumed to be harmful, then you need to do it in every case. And I'm rather optimistic that if we do it that way, we will only have to go into by effect analysis on a case-by-case basis in a number of cases where we can afford to do it. Another issue is then still whether we will have the time to do it. Because one thing is you have the resources to go into a really substantial economic analysis, and another is, can you do it within a reasonable period of time? And that is, especially in merger control cases, always an issue.
Of course.
But it should not only be an issue in merger
Right.
control cases. We should compress the time we spend on all cases.
Speaking of time, of course, time is of the essence in many markets. Are you satisfied with the length of investigations in some big cases by the European Commission? Do you find, I know it's, of course, it's a sensitive and contentious question, but in many abuse of dominance cases, for instance, investigations will last for 5, 6, in some cases, more time. Do you think it's a satisfactory approach?
No, it cannot be satisfactory. But some things that are not satisfactory are nevertheless difficult to avoid.
Right.
Let's look at it at a type of case by type of case basis. In merger control, I think we now have a system that works reasonably well and delivers results within an acceptable period of time, taking into account that between 70 and 80% of the cases can usually be dealt with in a simplified procedure.
Sure.
That means well within 1 month. The other cases, you see that although the figures of last year seem to be a bit different at the European level, but you see that most cases are dealt with in a phase 1 non-simplified procedure, extended when necessary in order to discuss remedies.
Sure.
Which seems to, which almost makes me say that at phase 2, you only go into it when you intend or envisage a prohibition, or when something really went wrong in the first phase and you didn't get the right answers at the right time. So phase 2 is exceptional. Taking that into account, I think that the overall management and including the time it takes for merger control is reasonably satisfactory. That's not a case when we look at infringement cases. But at the infringement cases, you have the time the authority spends on the case and the sometimes prolonged suspension periods when there is litigation with regard to dawn rates, etc.
Right.
That is in the hands of the court, and there's not much we can do about that as competition authorities. But with regard to our own investigations, I'm inclined to say that we should go for a target of 2, maximum 3 years.
Right.
Of investigations under our own control. But if you look at some of the more recent decisions, we're getting reasonably close. And if you look at the decisions of, for instance, our French friends, they're very close.
Absolutely.
If you look at our Dutch colleagues, the same. So you cannot say that they take bad decisions. So it must be possible to do it within maybe more like 3 than like 2, but it must be feasible, I think, to do it within that type of framework.
I see.
But we're not there yet. I have a major proviso. There is a risk that if we really go for that target, we might avoid complicated cases.
Right.
Because the target is manifestly much easier to reach with regard to hardcore infringements than with regard to other decisions. With regard to the other decisions, and there are not all that many, if you take the list of major cartel cases of the with abuse and hardcore, it's a different story. But take the major cartel cases. Most of the cartel cases are hardcore. Now, it's not rocket science to say that a horizontal price agreement is an infringement of the rules of competition.
Absolutely.
You don't learn much to the market by saying so. Your useful effect is the deterrent effect rather than the educational effect.
Sure.
But the market needs education as well. So sometimes I think you must have the freedom to take up a more complicated case, which then takes inevitably more time, where the decision probably comes at a time that it makes no difference whatsoever anymore to the parties directly involved,
Right.
but where it may still provide guidance to the market at large. Given these problems, I think that we should, and there our experience is a bit different from the one of the European Commission, that we should not hesitate to take what is often referred to as positive decisions. Decisions that you do not see the reason to pursue because you do not, we are not allowed, as you know, as a national authority to decide that there is no infringement if the EU rules apply. But that we see no reason to continue, which basically means that we see no infringement.
Absolutely.
As I'm sure, and that is also what stakeholders tell us, that it is for the market very useful not only to know what is prohibited, but also what is not prohibited, so that we gradually limit the gray area to one that offers as much legal certainty as possible. You can do that by positive decisions. You shouldn't have too many of them. I think the Belgian authority has, certainly during a certain period, had too many. The percentage was wrong, which shows that we were probably too eager to open a case.
Right.
I think we gradually get the balance better, but it should remain a balance. It should not. I don't think that eliminating the positive decisions would be a good thing. And then you can also try to offer guidance with your informal policy and with your advocacy policy. Guidance is certainly, stakeholders, as you well know, continue to press us for guidance.
Absolutely.
And the undertakings themselves even more than the bar. That's also natural. With timing, then we should also try to limit the negative impact of duration by bringing forward the useful effect as much as possible. But there are limits to what you can do. I think many of us have the experience that the impact of an investigation on the parties directly involved starts at the investigation and not at the decision. Only in these gray zone areas where they may well hope that there is no issue at the end, will they not adjust their behavior until they see the decision. But mostly the useful effect comes much earlier.
Right.
And therefore, I think that it was also right, we will do the same, that the Commission has adjusted its assessment methods of the useful effect of their decisions. But to issue a press release when you open an investigation is, I think, not acceptable to the stakeholders and not acceptable to us either. Because the probability that you will end up with an infringement decision is too low, and you have not properly investigated, you have not properly listened to the companies involved. So the compromise, if you look at authorities, a European Commission, at ourselves but also at others, is more or less that we issue a press release when we issue a statement of objections.
Right.
And that when somebody goes to the press with a dawn rate and come to us to ask for confirmation, we do not deny it. But we don't issue press releases, and we never, at least in the Belgian authority, we never mention the companies even when we are asked to confirm about the dawn rate. So that seems to be the compromise of bringing the useful effect forward, not so much for the parties directly involved, because that's not so much a problem, but that the market at large knows as soon as seems fair that something is seen by us as a problem.
Right. So you were referring to the educational role of decisions, mentioning that it might be a good idea to have more positive decisions, if only to provide guidance.
That means more than just none.
Right. What do you think of the use of commitments decision? Because it's been, of course, a tool used more than practitioners anticipated when Regulation 1/2003 came up.
Yeah.
So do you think that it's a tool that has been overused, or what's your view on these decisions?
I think that the issue of commitment decisions should be looked at together with the issue of settlements. And that the choice of the tool in your toolkit it depends to a significant extent on the structure of your authority.
Right.
If, like the European Commission or like the Dutch authority, you have a structure where basically the investigation, prosecution and decision making takes place within the same entity, not just legal entity, but functional entity, commitment decisions can be a very good option.
Right.
But the negative point is becoming more important now that we have in Europe the damages directive. Because a commitment decision is a decision without acknowledgement of infringement.
Right.
That means that the feeling will, I think, increasingly be that you deny the consumers, the stakeholders, the potential victims of an infringement, some of their rights by going for a commitment, while in case of a settlement, they have something they can use in court.
Right.
So, conclusion, even when you have a fully integrated, functionally integrated authority, commitments were certainly a good instrument, but they may have to reconsider it in view of the rights of third party, of victims. When, like us, you have a functional separation within an integrated authority, but a functional separation between, on the one hand, investigations and prosecution, and on the other hand, decision-making in formal cases, given the fact that commitments have to be accepted by the college in the formal procedure, you don't win any time or resources by having a commitment decision.
Absolutely.
Which is one of the main reasons for authorities like the Commission to go for it. So the formula has never been attractive to us and has not been used in the last 10 years. Settlements were only introduced in Belgian competition law by the 2013 Act. Settlements are handled by the investigation and prosecution side of the authority. So I am not involved, but I have the impression that there might be settlements in the pipeline, if I read the press, which I'm allowed to do.
Sure.
So settlements, I think, have a much bigger chance to be used by the Belgian authority than commitments everywhere. I think now we still have the commitment provision in the law, but
sure. So speaking of functional integration, of course, one of the criticisms that is often made with respect to authorities that are functionally integrated relates to due process. As you know, it's a sensitive issue. It's an issue that comes regularly on the table, especially coming from practitioners who are, or clients, which may be frustrated of the processes. Do you think that it's a bit unfair to claim regularly that due process is not sufficiently complied with or respected? And I'm speaking of EU investigations, not Belgian investigations.
Well, first we have the separation, and we always had it.
Sure.
And government and parliament were extremely attached to it. So discussing that was simply a non-issue.
Absolutely.
But that doesn't mean that the other systems are necessarily unfair, unjust, or whatever. My feeling is that the European Commission has more of an image problem than a substantive problem. Yes, it has. It must have happened occasionally that there was a prosecutorial bias in an the investigating team, that's more or less, it's not to be expected, but but it's unavoidable that some teams are more like that than others. But I have the impression that certainly in the last 10 years or so, their internal system of checks and balances avoids that to be a real substantive problem. The problem is that they cannot show the working of their checks and balances, because just imagine that negative reports coming out of the checks and balances are available to all concerned.
Of course.
And you then take a decision that takes into account some of them and not all of them. I mean, that's a red carpet to the general court. So you cannot do that without damaging the system. I understand that. But that means that he will probably have either to change the system or to live with these reactions.
This leads me to a question about transparency.
Yeah.
Do you think that competition authorities should be transparent, or do you see limitations to transparency? You've just mentioned one, which is that, of course, you cannot share with third parties disagreements within the institution over a point of law. But generally, do you think there is enough emphasis on transparency?
I think so, yes, but my view may be biased. But no, frankly, I'm first thinking of our own procedures. The parties involved see everything. Third parties, not. It's the auditor, so the competition prosecutor, and the parties involved who decides what will be in the procedural file.
Right.
Because it's their written positions and the evidence they have used. The college only sees what they want us to see. We really do not see anything else. That was different in the past.
Right.
And if there is an appeal, the appeal judge sees what the decision makers, that means the college, has seen. Our decisions are published, and we publish them quickly, if I may say so. What else can you see as a problem of transparency vis-à-vis the parties? Now, the outside world sees the decision. The decision must be motivated. They do not see the underlying evidence, and they cannot get access to it.
For obvious reasons.
For obvious reasons. So there again, I think that the balance between what should be confidential and what needs to be transparent should be more or less right.
Right.
From my perspective.
Now, one question I want to ask you as well relates to commissioners, because you've seen a number of commissioners.
Yes.
Different styles,
Oh,
different
yes.
personalities?
Oh, yes.
Yeah.
So
So
nobody, I think, can question that Neelie Kroes and Monty and Joaquin Almunia are different personalities.
So, among the commissioners, did you have or do you have a favorite one? A personality that you found
No,
quite
I
extraordinary?
don't think that is a question. I want to go into it. What I can say is that the contact between the heads of authority and the commissioner have always been good in my experience.
Right.
But their styles may be different, and some commissioners really evolved during their mandate. Neelie Kroes was much more willing to go into a substantive discussion towards the end of her mandate than at the beginning.
Of course.
To give an obvious example. No, you always have to get a bit used to each other as they're all different. But now with Margrethe Vestager again, there's a very easy contact.
So a difference, of course, between the United States and the European Union is that the people at the top of the DOJ and the FTC typically are practitioners or academics with significant experience in competition law and policy before getting their position. In the European Union, traditionally, commissioners have been non-experts. Do you think there are advantages and disadvantages looking at these two different models?
Yes, but I would not exaggerate the disadvantages of our system. In my experience, the commissioners, whatever their background, have always very quickly become familiar with the key issues.
Right.
And on the whole, my experience with politicians is that they're very quick learners.
Sure.
At least successful politicians, and only successful politicians can hope to become commissioner for competition.
Absolutely.
So that is really a remarkable ability. All have. Monty had predominantly an academic background when he became commissioner. But when he became commissioner of competition, he already had a mandate of internal market.
Internal market, of course.
So, no.
Like Commissioner Almunia.
Like Commissioner Almunia, who was not familiar with competition policy, but as Commissioner for Economic Affairs,
Right.
Had substantive experience in a very related field.
Right. Speaking of the Court of Justice, you were a legal secretary. In American parlance, you were a clerk to one of the judges. Did you see a major evolution in the court?
Oh yes, I was legal secretary to the president at the time that the court employed, gardeners included, because I think there were one or two, approximately 300 people.
Right.
With the translation service, which was the biggest, by far the
Sure.
biggest of the services. Now you talk about a few thousand. That's a completely different organization. At that time, you had the court, full stop. Now you have the court, the general court, the civil servants court, etc. You had, at that time, Spain and Portugal were not member states yet. Now you have to. No, it's really a different world, where a much greater output is expected. But then there are also many more people to produce.
More clerks, more judges. One criticism you could do about the Court of Justice or the General Court, let's say the court as a whole, is that there is a fair amount of inconsistency in the decisions. Let me explain. If you look at abuse of dominance cases, it's a bit difficult to reconcile a case like Post Denmark with, let's say, a case like Intel. Do you think there should be more coherence, and perhaps the Court of Justice should try to use its sort of role of a Supreme Court to ensure a greater coherence in the case law?
The cases you mention are indeed also for us not easy to read. So whether you could qualify it as an inconsistency or as a lack of clarity in the case line, I'm not saying on a case-by-case basis, that is something only future cases will show. And when Intel, when there has been the appeal case, we will be better placed to discuss this. But on the whole, there are not that many examples of potentially inconsistent cases. There has been at a certain period certain wavering on fields, in certain fields, but like collective dominance. But then in the end, it usually gets clarified.
Right. Would you be favorable to a specialist court for competition cases, a sort of CAT, but Competition Appeals Tribunal, but for the European Union.
At the level equivalent of the General Court?
Yes.
So with the possibility to have an appeal on issues of law to the court?
That would be the model.
Depends on the caseload. What we now hear from Luxembourg is that the number of competition cases goes down significantly, and that while some time ago it might have been justified to have either a special court or specialized chambers, that may not necessarily still be the case.
Right.
And if I talk to friends in Luxembourg, they are more concerned about the number of IT-related cases than they are about competition-related cases. But in 5 years' time, that may be different again.
Sure.
So I would, on the whole, rather think of an specialization of chambers rather than a specialized court. And with the increased number of judges, they may be able to think about that.
Right.
Well, look at the Court of Appeal in Brussels. There's no specialized court, but everybody knows that the Dutch-speaking cases go to the same chamber, and that the French-speaking cases, well, there has been a bit more wavering.
Right.
There was a bilingual chamber, but that may be a more realistic formula, given the fact that the percentages certain cases represent in the total case law can change, and sometimes quite rapidly.
Right. So moving back to Belgium, what are the main challenges that you face? Recruitment. Why is it so?
Well, first, we had a budget-driven stop on recruitment. Then we became an independent agency, and nobody knew too well what that meant and how you, what procedures in recruitment were exactly applicable, etc., etc. And the different ministries had to convince each other that they could give the green light. The result was that for more than a year nothing happened. And then we had another budgetary blocking, which we are still in. The result is that we went down from 58 to 38,
right.
From 56, sorry, to 38 full-time staff, as we could never replace anybody. And our turnover is certainly not exaggerated. It's approximately 10% a year, which, according to some, is even ideal. So we must get the authorization to recruit. We have the budget. That's not for all the recruitments we I think need to do, but at least for a number of them. If we could already do that, I would be a much happier man.
Do you think it's a Belgian problem, or generally competition authorities have difficulties to recruit in the member states?
When you say difficulty to recruit, there is on the one side the authorization to recruit,
right.
and then the possibility to find the right persons.
Right.
We are not the only ones that have difficulty to get the authorization or the budget that enables us to recruit. Some don't have the problem or hardly have any problem, others have the same or similar. Finding the right people, I'm not too worried about that. Because if we really see a significant upturn of the economy, it might become more difficult, because if the law firms recruit, we have a problem.
Sure.
But if the law firms recruit less, they always recruit, I hope.
Yes.
They recruit less, we have a better chance in the market. It's as simple as that.
Yeah, of course.
If the law firms are more reluctant to make partners, very qualified senior people either set up their own law firm or might think of coming to us.
Sure.
Or something similar. So I think that there is a sufficient number of, because we're not going to recruit 100 people, that there is a sufficient number of genuinely interested, good young people willing to envisage coming to us. I don't think that all of them, and may not even many of them, will do so in the old or traditional civil service concept of stepping into it for life. Many will see it as an interesting
yes.
stepping stone to something else.
Yes.
Now, as long as they stay 4 to 6 years with us, that's fine with me. You're always sorry when you see a good person leave. But if a good person leaves to something good, the chances that you will get another good one increase.
Absolutely. You're entirely right. Okay. What about Regulation 1/2003? Major success?
Oh, yes. I would almost say unqualified success.
Unqualified success, I agree with you.
Incomplete success.
Why do you say incomplete?
Partly because of the success. I think the Regulation 1/2003 was very successful in organizing effective cooperation between the Commission and the national authorities. We saw no turf fights. Occasionally, there have been only a few cases where the allocation of the case was really disputed. The decentralization is a reality. I don't have the exact figure here, but at a certain moment it was of about 1,800 cases, only 300 opened at the Commission and the others at national.
It's spectacular.
That's an absolute reality. And in all the other cases, the convergence mechanism at the end functions. So it does not lead to widely differing interpretations of similar rules. So that is a success. But because decentralization is a success, the chances, risks, that a similar behavior is potentially dealt with by a number of national authorities has gone up.
Right.
The ideal solution is that in all these cases the Commission takes up the case, but that's not realistic. They don't have the resources to do that. So we must improve our coordination among each others in cooperation with the Commission in those cases. And the key issue we see at present is sanctions. Because we must find a balance between several concerns. If several of us deal with it, and we had a flower case, and several of them who deal with it can impose sanctions calculated on the basis of European or worldwide turnover, there is, I think, a significant risk of over-enforcement.
Yes.
If, on the other hand, only one or two deals with them, and moreover, there are ones like us who have to calculate sanctions based on domestic turnover, that is a real risk of under-enforcement.
Of course.
And you still have the no bis in idem issue, but I think that, frankly, there, given the case law of the Court of Justice, there is a higher risk of economic double jeopardy than of legal double jeopardy.
So, Jacques, in 10 days, or almost 10 days, we will have a new ICN meeting in Sydney.
Yeah.
What do you think of the ICN? Another success?
Yeah, it's another success, but it has seen, from my perspective, a massive transformation. The ICN was initially set up to realize a minimum of convergence in merger control. And it is in merger control that there is the biggest risk of conflicting decisions.
Of course.
Or the impossibility to live with conflicting decisions.
Yes.
That was achieved in about 3 years. Meeting, guidelines, follow up on best practices. Gradually, the ICN also looked at infringement cases. First cartels, now also abuse of dominance or unilateral conduct. There is less need for convergence. There is also less convergence. But there is a much bigger need for education. As we started as a small club of established authorities, now we have, 120 members, the majority of them being young authorities, often in emerging or potentially emerging, if I may use that expression, economies. If all of them apply even the similar rules, but with completely different backgrounds in completely different ways, I really think that competition law enforcement will not make markets work better, but will become an impediment
Right.
to international trade. That can never be the object. So from my perspective, the ICN has evolved from coordination club among the major economic powers of that time into an advocacy and training and educational institution to make sure that, or at least to make it as likely as possible that we all look at things in a similar way.
As a European spending a lot of time in the United States, I'm often asked about protectionism.
Yeah.
Is the European Commission protectionist? Even recently, today, some suggested in the news that, in fact, Europe was trying to protect its own tech companies by going after another US company. What's your view on this?
No, I really don't think that is the case. I see no evidence. I don't get that feeling when we talk among each other. No.
This is my traditional answer. I agree with you. I think that the European institutions are very tough enforcers, including on European companies. Most decisions concern European companies, and I don't think that American companies are treated worse than their European counterparts.
No, and of course, the priorities, the emphasis is not always the same. We tend to look more critically at unilateral conduct, and that is what is very often at stake in the cases you refer to. But then, indeed, I think without any discrimination or prioritization, depending on the origin of companies. No.
We're reaching the end of this conversation. Two final questions. The first one, what is for you a modern competition lawyer?
A modern competition lawyer?
Yes.
One who understands his client and who can translate the law and policy to the client and the client's legitimate expectations to the enforcers. And that is no different from what I think you could expect from a competition lawyer in the past.
Right.
But that a modern competition lawyer needs to have, as you said,
Sure.
Needs to have a greater ability to talk to economists and non-lawyers than before is probably fair to say. You also need more economists who are able to talk to lawyers.
Absolutely. My final question relates to the evolution of European competition law. How do you see it evolving in the years to come? Is private litigation something that will change
what has
the
always
setting?
Surprised me is that when talking about private enforcement, whether you look at commission studies or at the bar or academia, people always focus on traditional antitrust, on cartels.
Right.
And forget that with regard to abuse cases, there has always been private enforcement. There's more private enforcement, I think, than public enforcement in a number of our jurisdictions. So when you now facilitate, to some extent, private enforcement with regard to cartel cases, I don't think that private enforcement will not be used in Europe. What I do expect, however, and I think very few Europeans expect a different outcome, is that we will predominantly see follow-up actions, initial actions. It is very difficult for us to know whether there's a cartel. So it is inevitably even more difficult for a consumer in the street. You may think that you pay too much, but between thinking that you pay too much and having at the beginning of evidence that you pay too much because of a cartel, that's two different stories.
I would like to thank you very much for this conversation. I truly enjoyed it, and I hope that the viewers will appreciate this conversation. I think it was very full of substance. So Jacques, thank you very much.
Thank you.
Thank you.